Yes.
There, please, Your Lordship. Your Lordship, I beg to mention WPC number 8966 of 2019 for listing on Monday for withdrawal, Your Lordship.
Mention before the appropriate senior bench. Yes.
Well, I beg to mention item number 10. Here I am supposed to file affidavit in reply. Recently they have
It's a 2015 matter.
Yes,
Please
yes,
wait.
Yes, recently they have filed their.
Wait.
Okay.
Yes. Call the list.
May I please, Your Lordship? One item number 6 hearing, Lordship. Item number 6 hearing.
This is that Bhadgila Barks.
Yes, yes, Lordship.
Yes.
Passbook for time being, Lordship, because I
It's
have
a
one
apartheid matter, Ms. Boro.
passbook because in port number 1 I have one matter, Lordship. So passbook for time being.
When do you want it?
As soon as I
Time being.
Time being.
All right.
What the time?
Okay.
In this case, Lordship, I am filing affidavit today. In fact, I have served a copy to my friend, Lordship.
You have filed the affidavit?
Lordship.
All right, Kalpana. Mr. N. Upadhyay, Learned Counsel, appearing on behalf of the Irrigation Department, submits that the affidavit in opposition in terms of the earlier order
Lordship.
passed
On
by this court on 9/10/2023
Yes.
has been filed today.
Lordship.
Stop. However, the same is not available on record. Let registry verify and place the same on record. List
After 2 weeks,
list on such and such date.
Oblige.
I'm appearing for 3 and 6.
Oblige.
Yes, Ms. Das, affidavit is filed.
File, my lord. Here we have sanctioned the amount of 2 lakhs rupees, my lord, provisionally.
Yes, I
But
think I have recorded this on the last occasion.
my lord, but
and,
the fund has to come from the
Revenue Department was allowed some accommodation to obtain instructions as regards the status
Yes.
of the provisional sanction forwarded from the Office of District.
I have
Yes.
received a telephonic conversation and the information that they are processing the thing and they will be paying it within 2 months.
No one is there for the petitioner.
Otherwise, matter could have been disposed of.
I think I can dispose it.
Yes.
Lordship
Yes.
can.
Your instruction is that it will be.
It has been processed.
It has been processed.
Processed.
So I will direct that in view of that endorsement, let everything be completed within the period of
2 months.
2 months.
Fine.
None, Kalpana. None appears for the petitioner when the matter is called. Stop. Heard M.S.U. Das, learned additional senior government advocate for the state respondent, and Mr. A. Bhattacharya, learned standing counsel, revenue and disaster management. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is seeking direction for payment of an amount of rupees 2 lakhs in words and in numericals only to the petitioner against the death of his brother
Yes.
in a road accident in terms of the notification dated 15/11/2014 issued by the respondent number 1 within bracket Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department, RNR branch Dispur. Stop. The facts of the instant case is that the brother of the petitioner, I. late Unisha Narjari, died in a road accident on 8/5/2022 on the Kahinala Udalguri Rautar Road under the Udalguri police station in the district of Udalguri, BTR, Assam. Stop. Accordingly, a case was registered as Udalguri PS UD case number 13/2022. Stop. It is the specific case of the petitioner that since his brother died out of motor vehicle accident in public area and he being the next of kin of the deceased, he is entitled to a relief of amount of rupees 2 lakh as per the notification dated 15/11/2014 issued by the Government of Assam in this regard. Stop. It is the further case of the petitioner that though a representation for financial assistance was submitted to the respondent authority on 14/11/2022, no assistance has been received by the petitioner till date. Stop. Accordingly, the instant writ petition has been filed. Stop. During the course of the hearing, MSU Das, that affidavit,
Yes.
don't say during a heard the respondents and perused the materials available on record. Stop. It appears from the affidavit in opposition
Number 3.
filed by the respondent number 3 on 21/5/2024 that provisional ex gratia amount of rupees 2 lakhs has been sanctioned in favor of the petitioner. Stop. Paragraph 4 of the aforesaid affidavit is reproduced hereunder for ready reference. Big green flag to us, star mari diso. Stop. Pertinent that upon noting the aforesaid averment made in the affidavit in opposition, this court by order dated 26/6/2024 directed the Standing Council Revenue Department to obtain instruction as regards the status of the provisional sanction forwarded from the office of the district administration. Stop. Today when the matter was called for hearing, this matter is called for admission.
Yes.
Today when the matter was called, Mr. A. Bhattacharya, Learned Standing Council Revenue Department, submits on instruction that
the process for payment has been initiated.
That the process for payment of the aforesaid ex gratia amount of rupees 2 lakh has already been initiated. Stop. And he accordingly makes an endorsement to that effect. Stop. Next paragraph. In view of the aforesaid endorsement made by the Learned Standing Council for Revenue Department, this court is of the considered view that this writ petition can be disposed of with a direction to the respondents to pay the aforesaid ex gratia amount of rupees 2 lakh as sanctioned to the petitioner within a period of 2 months from the date of receipt of the certified copy of the order. Stop. Registry is directed to inform the petitioner by email as well as by post as regards the order of this court. Stop. Disposed of. With the aforesaid observation direction, the writ petition stands disposed of.
Much obliged.
Please give an appearance slip. Mr. Bhattacharya, since the petitioner is not there, you communicate this order.
Well, I will communicate.
Alright?
Sure.
I am not saying anything.
Yes, I will. Obliged.
Yes.
Lordship, CD is available, Lordship.
CD available?
Available, Lordship. But I need to state only one thing, Lordship. Here one report is there, injury report, but nothing is stated. whether it is grievous or blunt or nothing, Lordship. But when I look into the one court order, Lordship, court's order, here it is may I read, Lordship, the paragraph. Peruse the
Page.
It is not there in the
Okay, please
in
read.
the CD, Lordship.
Yes.
In my petition,
It is stated that as per the injury report of the victim, the nature of the injury is grievous and type of weapon is
One
blunt.
second, please.
Lordship.
Case 20.
7 and 8. Yes.
Lordship, it is written here, as per the injury report of the victim, the nature of the injury is grievous and type of weapon is blunt. From where it is found, I have not seen where it in a CD, it is not available, Lordship.
Also, just assisting the court, kindly come to page 20 of my petition.
This is the AB.
Yes,
Lordship.
yesterday also one petition was moved, Lordship. In fact, Lordship,
AB. All right, where is the, you are not on interim?
no.
Where is the FIR?
Yes, Lordship. Page, there is a 2 FIR, Lordship, one for a second. Page 10 is the
Page?
10.
10.
Yes,
Are you a named accused?
yes,
Serial number?
yes, Lordship. Serial number I am 3, Lordship.
Shaheenur Islam?
Yes,
Yes. Read the FIR.
yes, Lordship. Humble submission is that my son Nazimul Haq was untraced on 19/11/2023 till 11 p.m. I searched in several places but could not receive any information. At about 1:40 a.m., a phone call came from scene number so-and-so, whereby asked me to receive the dead body of my son from the house of Shahjamal Sheikh. Immediately, my younger brother, and 2 others approached to the house of Shahjamal Sheikh, and I have been assaulted with lathi on my shoulder. Then I returned back. After that, I, along with some village elderly people, went there and recovered my son in a critical condition. It is to be mentioned that due to torture inflicted by the accused persons with lathi, rod, my son sustained injuries on his various parts of body and broke his right hand.
So there is no overt act mentioned as regards the present petitioner, correct?
Sorry, Lordship.
His name is there, Lordship.
His name is there, but what I'm
Victim
saying...
also stated name.
Huh?
Victim.
So any specific role has been attributed to him?
In one, many statements are there of the victim's Lordship. In one of the such statements, Lordship, he has stated that one batal, it means that wood cutting, a sharp weapon, Lordship.
Huh?
It is used, carpenter used this, Lordship. He has inflicted injury by that, Lordship.
He means?
This.
The petitioner.
Lordship.
So one of the eyewitness...
No, himself, the victim.
the
himself,
victim
Lordship.
has... so there is one specific
Lordship.
role attributed to
Yes,
the petitioner.
Lordship. Yes, Lordship.
And the nature of injury, you say, is not
Not there,
is
but
not available.
I want to look into, if Lordship want to
No,
look into
you
it.
check. It
I
is not
have
available.
I have checked, Lordship. In this injury report, there is nothing.
There is
Lordship.
nothing mentioned.
But in the court order, it is stated that as per the injury report of the victim, the nature of the injury is grievous.
But on what basis that observation has
That
come?
is also, I am looking into it, Lordship. So I want this, it need to be up to date.
I think
Lordship.
it's you are...
Something may be there, Lordship. It may be not in there.
but otherwise, let him appear.
Lordship. Otherwise, in materials are there.
Let him appear.
Lordship.
Materials, only one statement is there,
Lordship.
that with what?
Batal, Lordship.
Let him appear.
Lordship.
10 days. All right. Earlier, I have disposed of one case connecting to
cases,
this
yes,
FIR.
that was
Where are those orders?
Yes, Lordship, I have annexed the Lordship page 18
Page?
18. Actually, there is a cross affair also, Lordship. The victim entered the house of the.
I have allowed.
Yes. Page 18.
All right. Those were a regular bail.
Yes, Lord. Right.
Item number 3. You are Mr. AZ Ahmed.
Yes.
Heard Mr. AZ Ahmed for the learned counsel appearing for the petitioner. Stop. Also heard Mr.
KK Das.
A.K. Das, learned APP for the state of Assam. Stop. This is an application under section 438 of the Code of Criminal Procedure 1973 for granting of anticipatory bail to Shahinur Islam, who is apprehending arrest in connection with South Salmara PS case number 334 of 2023, registered under section 147, 342, 325, 326, 307, 379 IPC. Stop. The allegation in the FIR is that the accused petitioner have assaulted the son of the informant. Stop. Mr. Ajad Ahmed, learned counsel for the petitioner, submits that the accused petitioner is totally innocent and is no way connected with the alleged offence, and that there are no materials to implicate the accused petitioner for the offence alleged. Stop. He further submits that the informant has lodged a false case against the accused petitioner and the police on suspicion has arrested. Sorry, sir. Here it has not been. He further submits that the informant has lodged a false case against the accused petitioner. Stop. Yesterday also, I think I have disposed of one case connected to this FIR.
Yes.
Page 19 of Jabba. He further submits বুলি আছে মই মাৰ্ক কৰি দিছো খালি ইয়াত ডক্টৰ অফ দি একিউজ পিটিশনাৰ নম্বৰ 1 আছে তো হেডু কো একিউজ কৰি দিব কো একিউজ ৰাইট
Yes.
till 20 মাৰ্ক কৰি দিছো Mr.
KK Das.
A. Das.
KK.
Mr. KK Das, learned APP, Assam, on the other hand, strongly opposes the prayer for bail. He submits on the basis of the case diary,
Input materials are there.
case diary that there are implicating materials available against the petitioner. Stop. I have heard the parties and perused the materials available on record. Stop. It appears that the investigation has substantially progressed. It further appears that the statements of the witnesses have already been recorded under section 161 of CRPC. Stop. It further appears that the co-accused that few of the co-accused have already been enlarged on bail by this court.
Yes, up to 5 out of 7 FIR accused, 5 already granted.
It appears that out of the 7
Yes.
co-accused, 5 of the co-accused have already been enlarged on bail by this court.
Yes.
Stop. Considering the totality of the matter, this court is of the opinion that custodial interrogation of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, the petitioner named above, in the event of arrest, shall be allowed to go on bail of rupees 30,000 for the aforementioned case. Satisfaction of the arresting authority for subject to the following conditions: 1, 2, 3, 10 days. Disposed of.
I know.
the report for orders.
Yes, Mr. Sharma.
My Lord, it was on 26th of June. There are lots of desire that it may be disposed of. But it is come for orders, my Lord.
Yes, Mr. Biswas.
My Lord, what had happened in this case, my Lord? They had
You are the petitioner?
Yes, my Lord. They had filed an IA for vacating of the interim order. Now, my Lord, thereafter this matter was posted today, my Lord. Now, my Lord, day before yesterday I received a copy of an IA from them, whereby two of the applicant in the IA have withdrawn from the case. But I don't see that in the cause list. I have not seen any IA number.
Any IA have been filed?
Yes, they have filed a second IA.
You have filed an IA?
Yes, my Lord, because two of
What is that IA number?
I know.
IA number to one IA.
I think it has come.
Then let this matter come up along with the IAs.
Yes.
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 But in the petition, my Lord, the DC has, my Lord, sent the affidavit and it's being filed today, my Lord.
All right. I will record both the submissions. MS Yudas, learned additional senior government advocate, submits that
And my Lord, the
an affidavit has been filed in the writ petition. In which WPC?
My Lord,
two,
In WPC 2868 of 2024 today. Stop. However, the same is not on record. Let registry verify and place the same on record. Stop. It is further submitted at the bar that two IAs,
One IA is
that
on record.
one interlocutory application has also been filed in the meantime, which is also not tagged along with the which is also not listed today. Stop. Let registry verify the same and place the matter again on
next Tuesday, my Lord. Tuesday.
Tuesday on such and such date.
Yes.
And one more thing, my Lord. One IA I am not going to press.
Which one?
Application.
That is
IA number 1851 of 2024.
next IA. It will like
Because already, since your Lordship is going to take up finally, so I am not going to proceed.
I 1851. So I will say you're not pressing, and accordingly I will close this IA.
Yes.
In that IA 1851 of 2024. Mr. R.P. Sharma, Leonard Senior Counsel, assisted by
D.
Doloy, submits that he has received seeks to withdraw the instant interlocutory application since he has received instructions from the client not to press the same, and accordingly makes an endorsement to the same effect. Stop. In view of the aforesaid endorsement, the interlocutory applications stands dismissed on withdrawn. Stop. Upor did you heard everyone?
Hello, Dole, not Dole. Dole.
Dole.
The appearance disposed of.
Hello.
People read petitioner did you order?
My Lord, next Tuesday, my Lord.
Your Lordship, Senior Counsel Mr. Jain Sahiwala is on legs.
That I think Miss Bora is not there.
The time being, my Lord.
6 and 7 is different. Who is appearing for the respondent here? It's a land acquisition compensation matter. What is this matter?
Your Lordship, this matter has been already heard. It's regarding the SP Kasar acquired a plot of land from the petitioner to establish a police outpost, and same was established way back in 1973. Since then, the petitioner is submitting representation for compensation of the land.
1973.
Yes, Your Lordship.
Land was acquired.
Yes, and a police outpost was established.
Acquired for
establishing a police outpost.
Establishing police outpost.
Yes, Your Lordship.
Who acquired the land?
SP Kachar.
And since then, no
Nothing has been
compensation?
done. The petitioners are, since then, they are filing representation before representation.
Where are your representations? You had submitted a written argument.
Yes, Your Lordship. Page 12, page 13, 14, 15, all are my representation, Your Lordship, in my writ petition, Your Lordship.
Rupak. Yes, any affidavit filed?
Yes.
What is the stand of the state government?
Stand is, my lord, the land was donated, in fact.
Land was
Donated.
donated.
Donated. Lordship will kindly take up every bit, my lord.
Paragraph 10.
Paragraph 4, Your Lordship.
Paragraph
4.
of the affidavit.
Affidavit in opposition, page number 2, paragraph 4, Your Lordship.
Yes, please read.
Was donated voluntarily by one so and so, the late father of the petitioner, on verbal agreement for construction and setting up of a police watch post titled Rajtil so and so.
So there is nothing on. There is no written
Nothing is on
document.
record, Your Lordship.
Nothing on record. It was all verbal. Then, in lieu of that land, my lord, they tried to. They applied for a post of constable, and
Sorry?
the son of the petitioner applied for a post of
Yes,
constable.
paragraph 10.
Right. And however, subsequently he was not direction given.
But how the land can be acquired in this manner, Mr. Talukdar?
My lord, not acquired.
No.
He voluntarily donated. That is
Whatever,
our
but where is the document?
possibly nothing on record.
Then
These were all verbal.
Then, and since
73, he could have, my
the
lord,
petitioner has been filing representations
filing representation much later.
from 83, I think. 73, yes, I have. The annexure 1, it's a 73. The father himself writes. He says, as per earlier discussion, you assured issue a letter of acquiring so and so. You also promised that you will pay the compensation of the land. Page 11.
Yes, it is 70.
Correct. There is nothing mentioned. The father doesn't mention about donation. Then followed by 1985. Then 87. Then 2024. 2010. What can be done, because I'm not going to keep this matter pending. It's a 2014 matter, and admittedly the land of the petitioner is now being used for police outpost.
Yes, ma'am.
Next is that police outpost is there and it is still functioning.
Correct. Now, whether it was donated, not donated, that part is not. There is no document.
There is no document to show. Even he doesn't have anything.
According to him, it is not donated.
We are not claiming
He is
was
not
not
saying
donated.
because his
I have
document,
already filed my written argument, Your Lordship.
his document at page 11 is clear. Have a look at page 11, Mr. Talukdar. According to them, it is not a donation, case of donation. It is only the government who is saying, and for that you have nothing to show. Now, if that be so, if we follow Tukaram's case, Kolkata municipal case, you cannot just take the land
Take
of
over.
the petitioner without following the due process of law. It's a constitutional right of the petitioner. He's been deprived of his land since 73 and no compensation paid till 2024.
We have denied having any such.
But
This-
there
this
is no
event isn't
material
also-
for you to show
Man,
that this land was donated.
It's not donated, Your Lordship.
Is there any material? Mr. Talukdar,
then, my lord, this
there's
will
no,
be
huh?
this will be a disputed question of fact, my
No,
lord.
disputed question
Whether-
of facts, for that something has to be there.
And he has also to establish, my lord.
What is disputed? Is it disputed that he is not the owner of the land?
He was the
Then-
owner. We say that it was donated.
Correct,
Whether-
and for that you have not shown anything. Donation cannot be verbally done when it comes to land. Article 311.
Yes.
How can he be deprived of his land without any procedure? If there was a donation, then there has to be some document showing that it was donated. Where is that document? In the absence of that document, how can you say that this is a disputed question and this court shall not enter into it? As far as this court is concerned, he is the owner of the land, and admittedly, you have taken his land way back in 73 and established a police outpost without paying him a penny. That's an admitted fact. Yes or no?
Yes.
Then how can that be done?
That's what we say. We say that he had donated the entire ground.
They assured us to pay reasonable compensation for the aforesaid land to the petitioner, Your Lordship. On that assurance, the land was
Where
given.
is your affidavit in opposition? What do you say about this document on 3/10/73?
Representation.
That representation, what is your stand?
Yes.
You see, there is no denial, specific denial also. Isn't it? Have you denied?
No, Lordship, I'm sorry. There is no such reference. Paragraph 7 and 8 of our introduction.
Paragraph
7 and 8. Six also. That which regard to a statement made in paragraph 6 of the petition that the
You are saying no such reference of
No
claiming
such-
of compensation by the father is available on record.
Mine.
Then,
There is no such record. in
and para 8.
the
Then
subsequent-
I think the best course perhaps would be to refer this matter to the jurisdictional deputy commissioner to cause an inquiry,
Yes, ma'am.
and if the land has been taken, to
Your
do
Lordship,
the needful in accordance with law.
Yes, ma'am. That can. Yes, that will be the proper course.
Your Lordship, already they have acquired this land, the Deputy Commissioner.
Yes,
Kasar.
but you see, the stand of the government is that you have donated. Rightly or wrongly, we are not getting into that because this court cannot go into that question,
Yes,
right?
Your Lordship.
Because they are asserting that it has been donated while you are denying. And you have produced few letters written by the father who's donated.
Yes, Your Lordship.
The veracity of those letters are also disputed in their affidavits. They have said that these letters are not available. That means there is some dispute as regards your claim, isn't it?
Yes, Your Lordship.
Now, this court under Article 226 cannot go into it. So the best course, instead of keeping it pending here, would be for the district commissioner. Let him cause an inquiry. If it comes that this land has been acquired without there being any preceded by any donation or gift deed or anything, then you will be entitled to compensation.
Your Lordship, this issue was already settled. They have acquired this, the Deputy Commissioner Kasar has acquired this land by letter dated KCS 9/81, and upon we have investigated this and got this file number from the Deputy Commissioner Kasar, and same was not provided to us. We filed an
Mr.
RTI.
Counsel,
Your Lordship.
please answer one query of this court. Acquisition, I have understood
Yes, Your Lordship.
that the land was acquired.
Yes, Your Lordship.
As regards compensation,
Yes.
now their stand is that it was donated.
Yes.
If a land is donated, then the question of compensation will not come in. Correct? Now this is what they are saying. Whereas you are saying that this was not donated.
Yes, never donated.
No, never
Your
donated. So
Lordship.
that is why I am asking the jurisdictional DC to conduct an inquiry.
Already they have issued this letter number, but
Page. From where are you showing?
Lordship, just we have got this letter number from the Deputy Commissioner Kasar, and same was not provided to us.
Which saying what?
This letter number, the letter by who is the Deputy Commissioner Kasar has acquired this land. Letter number KCS 9/81.
From where are you reading it?
Just list of this, but we, as we have not, as that letter was not provided to us by the Deputy Commissioner Kasar, we filed an RTI, and upon filing the RTI, the same was not provided. With all these things, upon fulfilling all these things, we have come before this court, Your Lordship.
No, then the Deputy Commissioner will take into consideration of
He have
that
admitted
letter.
that this land was acquired.
If that is there, that letter is there, he has not annexed that letter.
No, it was not provided by the Deputy Commissioner. And
But your prayer is for compensation,
Yes,
correct? Now, this court is saying instead of directing compensation, this court will direct the Deputy Commissioner to make an inquiry and do the needful. If you are entitled for compensation, you will get it. Let an inquiry be done.
Your Lordship.
Isn't it?
Yes, Your Lordship.
Because otherwise, how this court is going to issue a mandamus when the other side is disputing the facts? Then the other course will be to send it back to civil court. It will not do any good to you. The matter will be unnecessarily get delayed, isn't it?
Yes, Your Lordship.
I think an inquiry perhaps would be the best course.
Within a time-bound manner, that should be done, Your Lordship.
All right. Doctor. Heard Mr.
Z. Khalid.
Jet Khalid, learned counsel for the petitioner. Stop. Also heard Mr. B.K. Talukdar, learned. You are appearing as the additional senior government advocate. Learned additional senior government advocate, assisted by Mr. A. Chetri, learned government advocate. Government advocate.
Yes.
Advocate Korea. And anybody else? Is revenue there?
I appear for all. Revenue is not there.
For the respondents. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is seeking compensation, is seeking inter alia direction for payment of compensation of the acquired land of the petitioner as per law. Stop. The facts of the case is that in the month of December 1972, police party led by the then Superintendent of Police of Cachar district requested the father of the petitioner, I. Keramat Ali Borbhuya, to give his land located at village Haritikar which is about 14 katha within bracket which is about 14 katha in dag number 347 of patta number 139 for establishing a police watch post. Stop. Accordingly, the father of the petitioner agreed and the police authorities acquired the said land of the petitioner. Stop. However, no compensation whatsoever of the land was paid to the petitioner's father. Stop. Though several letters have been written from time to time, neither any reply nor any compensation was paid to the petitioner. As such, the writ petition has been filed. Mr. So-and-so learned counsel for the petitioner submits that though the land of the petitioner was acquired way back in 1973, despite almost 45 years have been lapsed, no payment whatsoever has been paid till date. Stop. He further submits that non-payment of compensation has deprived the petitioner from his constitutional and basic human right over the said land. Stop. Next para. Mr. B.K. Talukdar, additional senior government advocate, on the other hand submits that it was the father of the petitioner who donated the said land to the police authorities and therefore no question of giving compensation arises. Stop. Donated voluntarily. Heard the parties and perused the materials available on record. Stop. It appears that the petitioner's land was acquired in the year 1973 for establishing police outpost. Stop. It further appears that no compensation has been paid till date as regards the acquisition of the said land of the petitioner. Stop. It further appears that since 3/10/73, the petitioner's father, and after the death of the petitioner's father, the petitioner has written several representations to the police authorities for payment of compensation for the acquired land of the petitioner. Stop. The aforesaid representations are enclosed to the writ petition and marked as Annexure 1 to
1, 2, 3, 4.
5, right?
5.
5, no, not 5 is not. 1 to 4.
1 to 4, yeah.
1 to 4. On the other hand, it appears that the state government, by filing an affidavit in opposition on 13/3/2018, has taken the stand that the petitioner's father donated voluntarily the said subject land to the police authorities for construction and setting up of a police watch post on the aforementioned on the subject plot of land. Stop. Accordingly, the Rajatila police watch post was constructed by the department on the said land, and since then the watch post has been functioning in the subject land. Stop. It further appears that no agreement whatsoever has been produced to substantiate the aforesaid stand of the state government. Stop. In fact, it is mentioned in the affidavit in opposition that the said donation was done verbally. Stop. Paragraph 4 and 10 of the said affidavit in opposition are reproduced hereunder for ready reference. Page 20 or 22 power. There. It further appears that the state government has also taken a stand in the said affidavit in opposition that the representations filed by the petitioner's father are not available in the records maintained by the concerned office. Stop. Paragraph 7 and 8 of the said affidavit in opposition are also reproduced hereunder for ready reference. Page 21. The factum of possessing the land of the petitioner appears to be an admitted fact. It further appears that despite of such possession, no compensation whatsoever has been paid to the petitioner till date. It has been almost 45 years?
45 years.
45 years since the respondent authorities have taken possession of the land of the petitioner and constructed a police outpost in the said land. Stop. Though the stand of the police authorities is that the said land was donated by the petitioner's father, stop, no agreement, no written agreement or covenant whatsoever has been placed before this court. In fact, the respondents contend that the said arrangement was verbally done. Stop. In the absence of any agreement, covenants, it is difficult for this court to come to a conclusion as whether the land of the petitioner was donated to the respondent authorities. Stop. Be that as it may, the right of the petitioner over the subject land being a constitutional, basic human right constitutional, comma, statutory and basic human right, comma, the same cannot be deprived without following the due procedure of law. Stop. Transfer of property ekhon ache neকি? Reference is made to the case of Tukaram Kana Joshi and others versus Maharashtra Industrial Development Corporation and others of the Apex Court, reported in 2013 1 SAC 353. Paragraphs 8 to 12 are reproduced hereunder for ready reference. Reference is also made to 2024 SSC online SC 696. Reference is also made to the decision of the Apex Court in the case of Kolkata Municipal Corporation versus Bimal Kumar Shah, reported in 2024 SSC online SC 968. Next paragraph. However, without decide, be that as it may, this court is of the considered opinion that this writ petition can be disposed of with a direction to the jurisdictional district commissioner, to cause an inquiry as regards the claim of the petitioner and do the needful in accordance with law. Stop. It is needless to clarify that the said exercise shall be completed within a period of
2 months.
2 months from the date of receipt of the certified copy of the order. With the aforesaid observation direction, this writ petition stands disposed of. That is sufficient, I think. I shall just edit a little bit inside. Pending IA, if any, shall is also stands disposed of. Separately deeded by orders. 85. No, disposed of.
Published.
Yes. 5.
Well, there are many points, but I am only considering only one point, my lord, because that is a Supreme Court held it mandatory, and our High Court has also.
That is?
Our High Court has considered the same, my lord. My lord, here what happened? Section 10(7).
Section?
Of the food license.
Mrs. Aiwala, section?
10(7).
Section?
10(7).
10(7).
Section 7, yes. That has been held, my lord.
Yes.
Where food inspector takes any action under clause A of subsection 1 of subsection 2, subsection 4, subsection 6, he shall call one or more persons to be present at that time, and when such action is taken.
You are reading
subsection 7.
Subsection 7. Yes, I've got it.
Where food inspector takes any action under clause A, subsection 1, subsection 2, subsection 4, subsection 6, he shall call one or more persons to be present at a time when such action is taken and take his or their signatures. My lord, he has to, my lord, call for independent witness.
He has to call for?
Independent witness while taking the sample. And Supreme Court has said calling for independent witness is a must. Mandatory. If he does not get it, then he can ask his, my lord, peon to take it.
Here there has to be first an attempt. If there is no independent witness available,
my lord,
then he can
ask his peon, my lord, to give.
But there has to be a finding to that effect.
My lord, yes. Here, my lord, these evidence, my lord, I have quoted. Just your lordship may see last time. At page, my lord, 3 of the petition, my lord. He went at 7 p.m., my lord.
Yes.
My lord,
Page 3.
Page 3, para 3.
Page 3, para 3. Oh, this is the judgment. You are challenging what in this
Well,
petition?
conviction under section 716 of the Food Act. Conviction.
Conviction.
My lord.
You are saying the conviction has been vitiated because of non-compliance of the mandatory
Yes.
requirement?
Yes, that is right. There are other points also I am not placing because this point itself will not suffice. There are 3. Page.
Yes.
During trial, 2 witnesses were examined. PW1 Sanjay Borwa was the food inspector. PW2 Fakrul Islam is the inspector of food and civil supplies who accompanied him at the time of inspection. During evidence, food inspector gave a detailed report as to how he took the samples. Some of the evidence which was relevant purpose extinct. During any inspection, my inspection, I observed that stock of mustard oil was kept in incendiary condition in open dumps. So on suspicion of contamination as well as adulteration, I expressed my intention collecting sample of mustard oil kept in open drums and sealed tins which were manufactured, stored and exhibited for sale of human consumption in a bin. Accordingly, I requested Mukhtar Ahmed, Sub-Inspector of Police, Hybergaon TOP, and F. Islam, Inspector so-and-so, Nagaon, who accompanied me during inspection of the mill, to remain as witness of my sampling and seizure. My lord, here I am submitting Mukhtar Ahmed has not been examined. Fakrul Islam has been examined, and if you lordship see the evidence of Fakrul Islam, he went there lately, my lord, page 5.
Mukhtar Ahmed is not examined.
Not examined.
Not examined.
Not. Fakrul Islam has been examined.
He is witness number
2, PW2.
F. Islam. F. Islam.
F. Islam.
PW2.
Yes,
Where do I get his evidence?
well, page 5.
Yes. You have extracted it.
My lord, yes. PW2 examines in question. I went to the place of occurrence slightly lately. Initially, everybody together inspected the articles and they had to see the same. The bottles were of plastic. I do not remember how many samples were taken. I do not remember how samples were taken. I do not remember how sample was kept in hospital. He does not know anything, my lord. He does not know how sample was taken, how it.
No, but from here it appears that there was no attempt to get an independent witness.
Yes. Well, that is the only thing. Entire evidence I am having, my lord, nothing is
Is there anywhere to show that they
On that point, I want to
Yes.
submit that, Chief.
because that is the only point as of
Lordship.
now urged by the Latvian Council, right?
Lordship.
So,
Food and civil supply officer is also dear Lordship.
Acha, 1 second. Before I go there, any decision you are relying on that point?
Well, that 2 judgments, my lord, of our the Supreme Court as well as our High Court. Supreme Court is 74 Supreme Court, and that was relied in
1974 Supreme Court paragraph, please.
paragraph, my lord, that is 4 and 5.
Paragraph 4 and 5.
And our High Court, my lord,
1990.
I'm just.
1992 GLR.
Yes, ma'am.
Paragraph.
Yes, 1992 JLR, page 99.
Paragraph.
My lord, paragraph 8, my lord, only. This may be seen, my lord. Supreme Court has been quoted here. Paragraph 8, my lord. I may deal with the next ground of acquittal, that is violation of section 10(7) of the Act. The contents say that food inspector did not call one or more independent witness to be present at the time of taking sample, which is mandatory requirement of section 10(7) of the Act. Section 10 deals with the power of the food inspector in the matter of taking sample of articles of food for analysis. Subsection 10 therefore provides, my lord, I am speaking. This provision came up for interpretation before the Supreme Court in Lamdavaya, so-and-so, wherein, on consideration of the language of this provision, in the background of the legislative history, it was observed that there could be no doubt that one or more person must mean one or more independent person. It was held that we are of the opinion that particularly in view of the legislative history of section 10(7), by taking action under any of the provision mentioned in the subsection, the food inspector must call one or more independent person to present at the time of when such action is taken. The Supreme Court, however, did not agree with the general proposition that regardless of all circumstances, non-presence of one or more independent witness at the relevant time would reset the trial. On the facts it was observed, the obligation which section 10(7) casts on the police inspector to call one or more person to be present when he takes action. The facts in the instant case show that food inspector did not call the neighboring shopkeepers to witness the taking of the sample, but none of them was willing to cooperate. He could not certainly compel their presence. In such circumstances, the prosecution believed the obligation to cite independent witness. My lord,
I think this page 104 last, from
Yes.
these observations, that would be
Yes.
important.
Supreme Court referred to earlier decision in so when it held that non-compliance section 10 would not initiate the trial since food inspector was not in a position to accomplish his evidence alone. I believe I cannot contain the referring to observe so. These
So
provisions
what is
make-
mandatory is given here. From reading of section 10(7) of the Act, it is
Yes.
clear that the provision is mandatory insofar as it relates to the duty of the food inspector to call one or more independent
Yes.
persons to
Yes.
be present
That is
at the time of taking the sample, etc. Therefore, the minimum that he has to do is to satisfy the court that all sincere so-and-so
Yes.
has been done. Yes, show
Yes.
me that
Yes.
that it was done, that he tried.
Lordship, at that place of occurrence, Lordship, two persons are there. Apart from the food inspector, one is sub-inspector of police, another is inspector of food and civil supplies and consumer
But
affairs.
they are not
Lordship.
independent persons.
But for being an independent witness, two things have to be, if they have dependent, reliable, Lordship. Two things are important. One is related. The witness has to be related.
Mr.
or
Das,
Lordship.
you cannot expand the provision, correct? Because it is clearly mentioned here that it is manifest that the object of this provision will be defeated if the inspector while visiting the shop carries with him his own peon
Lordship.
or any other subordinate to witness the taking of the sample. Now
Lordship.
here these are
These are the examples, Lordship, of the interested
now
Lordship.
these two people are subordinates or
No, Lordship. This person, food and supply. This does not
Mukhtar
come.
Ahmed is a sub-inspector of police, and who is the person
Who is food and civil supplies, Lordship, and consumer affairs.
They are superior.
Not
officers.
superior, Lordship. They
Then?
are of similar rank, Lordship.
Similar rank.
Lordship.
Not subordinate.
Not subordinate.
No, but then they will be covered by this judgment. Then they are similar rank. He could have called for someone higher or some other person
Moreover, I
from the
al-
neighborhood.
Lordship.
Mr. Das, you have to read this decision, the entire paragraph together.
Lordship.
You see, it is mentioned. Kindly see the Supreme Court's observation which is quoted in paragraph 8. The obligation which section 10F cast on the food inspector is to call one or more persons to be present when he takes action.
Lordship.
The facts in the instant case shows that the food inspector did call the neighboring shopkeepers to witness the taking of the sample, but none was willing to cooperate. So in that Supreme Court decision, they say did not vitiate.
Lordship.
Because there he made an effort to call an independent witnesses.
Lordship.
Now if the witnesses do not come, that is a different situation. But from the the inspector, he has to make that effort, correct? Now
Lordship.
here you are showing that he was accompanied by two officers
Lordship.
and both are equivalent to him in
Lordship.
rank. How can you say they are independent? They are officers of the same department and they are equivalent to him.
Not same department, Lordship.
Then
This is food, Lordship, and this is consumer affairs also, Lordship. Food and civil supplies and consumer affairs.
so government departments.
Do different government departments,
So
Lordship.
then why
But moreover,
was
moreover, one thing is also, dear Lordship, it only, Lordship, may I read, Lordship, does not vitiate the trial, and since the food inspector, it will weaken the evidence. Weight of the evidence will be weaken, Lordship. So they have to show whether the evidence is reliable or not,
No,
Lordship.
no, no, not on that. I'm not on that right now. First and foremost is to be shown whether it was called or not called. Number
Lordship.
one. Because by following the Supreme Court decision, this court have categorically held that
Lordship.
that part, calling, is mandatory.
The calling is mandatory, Lordship.
Calling is mandatory.
Calling is
So
mandatory.
where do you show? From where do you show that that he had called independent witnesses?
I am banking on Lordship, Inspector of Food and Civil
How
Supply.
can I don't know. You will have to address that they are independent witnesses. According to this court, they are not independent witnesses.
In some cases, Lordship, there are judgment, Lordship.
Where are those judgments?
I will place. I am not available
Then you
with me
place
now.
it, because it is apparent that he was not accompanied by any independent person, but two officers from the FCS and Consumer Affairs. No, one from the police and one from FCS Consumer Affairs. Correct?
Lordship. Here it is stated that in the judgment, Lordship, his peon or any other subordinate to witness, Lordship. Any other
That is
subordinate
not,
to that
that
officer, Lordship.
list is not exhaustive. You have to
Lordship.
understand what is the meaning given.
Lordship.
Right? It doesn't mean that only peon and subordinate.
Lordship.
The word is what is required, that he should be accompanied by an independent witnesses.
Lordship.
From independent witnesses would mean what? Independent witnesses would mean someone from the locality, someone who is not connected to the government.
Regarding that count, it is not written, Lordship, in the record.
Otherwise, they
I cannot show on
are
that,
interested
Lordship.
witnesses.
But they are the sub-inspector of police, Lordship, and these are different, Lordship.
Department is different, but they are officials of the state.
Lordship.
They are officials of the
Officials
state.
of
Correct.
states, Lordship. But they have to interested, Lordship.
They
and
are
relate-
interested.
But what interest that will have to
Anyway, you
carve out, Lordship.
Mr. Sayawala, let him show
Lordship.
if there are any other decisions he wants to show, so I
Lordship.
can have
Nothing
it.
to say, my lord. But so far, this the proposition is concerned, my lord, is still holding.
No.
Because
See, there
I'm
is
on
no
independent, Lordship.
there is no quarrel about that proposition,
Lordship.
right? But only thing, it does not clarify who can be, who cannot be.
Lordship.
If,
I am
the
on
ratio
Lordship.
is that it should not be someone who is interested.
Lordship.
Perhaps that is the ratio,
Lordship.
isn't it? An independent witness is, has to be present.
They are accompanied with the food inspector.
They are
So,
accompanied.
accompanied with the food inspector. So they cannot be. Two persons were there. One is police, my lord, and the other is food inspector.
Correct. There has to be an independent witness. Now, whether
That is why I
because-
say neighboring shops.
yes, because now these are state officials. Whether they can be said to be independent.
Well, because they accompany the food inspector. They cannot be independent.
Lordship, I only want to look into the this thing, Lordship, whether Inspector of Food and Supply will be independent or not, Lordship.
You can
On that
satisfy
count, Lordship.
tomorrow.
Lordship.
Tomorrow. List due to paucity of time, hearing could not be concluded. List again tomorrow.
Lordship.
Because only short point, unnecessary.
I only want- That is
why I
I
am
will
not going
forget
to
if
other
I
points.
and I'm not sure if I'm going to have a single bench next week.
Well,
So let's try tomorrow.
Lordship.
Otherwise, I'll forget. I'm keeping these.
Lordship.
Let's sing. This is that royalty matter.
Lordship, that Bricklane. They have submitted a written agreement, and in point number 1, they said they have framed and executive order under Article 162.
In the written argument.
In the
Yes.
written agreement.
I had submitted the last occasion.
Written argument. I shall just resume in 5 minutes. Written arguments.
They have admitted that there is no law as such.
There is no law.
But they have framed an executive order under Article 162. And for that, they have referred to 2 of the acts. And there is no rule framed thereunder. So therefore, they have framed this
Executive instruction.
executive order. So now, some clarification, my lord. I'm not very clear because there is no pleading to that extent.
Sorry?
There is no pleading to that extent in the my lord, affidavit that has been filed. So first thing, what I'd pray your lordship, my lord, requiring the respondent to show me which is the document they want to say that it is an executive order under Article 162. That is one.
That is not shown.
That is, I don't know, my lord, I have not at least found, my lord, as such, my lord. So therefore, whatever they are trying to say.
Which is the executive instruction?
They have been issued from time to time, which I have annexed in my affidavit in opposition. But since that query raised for the first time during the argument, we have incorporated, we have explained everything in the written argument. But if your lordship insists or directs, we may incorporate it in the 5 minute additional affidavit.
No, that will, because it's a question of law, so pleading as such may not be necessary.
No, but
in our affidavit,
you are saying that you have not seen it. That is why, in all fairness, Mr. Bhattacharya is saying that if required, an additional affidavit
he may point out the document which he refers to.
Because you see, Mr. Saikia, in that case, if an additional affidavit is filed, you will get a chance to rebut these things.
Yes.
Because right now you are not getting that chance.
Not getting so.
That might prejudice you.
Lordship.
Because we do not know in what direction ultimately the case will go, correct?
Yes.
I think it should, in all fairness, let them put it by way of an additional affidavit.
They can.
I can record that.
And secondly, they have also said, referred to two of the Act. One is Assam Land Revenue Reassessment Act 1997 and the other one is Assam Agriculture Rail Regulation of Reclassification Transfer for Non-Agricultural Purpose Act 2015. On that count, they said there is no rule framed thereunder.
No, I am saying that brickkiln is an industry in terms of the definitions contained in these two acts.
But it says, therefore, till rules are framed in this regard, the executive instruction issued in the form of government, the rules under which act, these two or any other act, which rule, under what?
It's not clear.
Which rule
it's not clear.
Yes, which rule
all
they
right,
are contemplating. I have third queries with regard to the last affidavit they have filed. In paragraph.
Mr. Saikia, you address all this in your
there's
reply.
some clarification perhaps would be required. In paragraph, if they clarify it, that will be better. In paragraph 12, they said that some part of the statement are knowledge and some part is the record. If they specify,
they have not specified
which part is the
anyway,
record.
That if they've not done it, perhaps this court cannot go into that, isn't it? How can we ask them to clarify? If it is not done, whatever follows will follow. Consequences. Consequences will follow.
But if they clarify it, then in that case,
all right,
it will be easier for me to argue.
This matter was heard in part, and during the course of the arguments, it was pertinent to seek instruction as under what authority the subject royalty was levied upon the petitioner. Correct?
Upon the we are saying brickkiln.
Upon the subject loyalty was levied. Stop.
Upon brickkiln.
Upon brickkiln. Stop. Mr. A. Bhattacharya, Learned Standing Counsel, Revenue and Disaster Management, had submitted a written argument on 26/2024 to submitted so and so with copy to the petitioner. Stop. Today, when the matter was called, Mr. P.J. Saikia, Learned Senior Counsel, assisted by Mr. R.S. Mishra, Learned Counsel for the petitioners, submits that a perusal of the written argument indicates that there are no statutory rules under which
enactment or
that the subject royalty levied upon the bricklayer is not in accordance with any statutory rules, but some executive instruction. Stop. He accordingly submits that in order to get a chance to rebut, the aforesaid submissions are required to be placed by way of an affidavit, by way of an additional affidavit. Stop. In view of stop, this court accordingly directs the respondent to place the written arguments by way of an additional affidavit, wherein the respondent shall further clarify
the executive order, pursuant to which they are trying to levy.
As regards the executive instruction based on which the subject royalty was levied on the bricklayer. Stop. That's all? Anything else you want?
And they also says that still rules are framed. The two act they have quoted, which rule, under what enactment, what statutory, the
He
act.
further submits that the two rules which have been quoted in the written submissions,
which rule they are contemplating to bring,
is
under which
also
enactment?
not clear as which is the rule that the state government is contemplating to bring in force.
No.
Huh?
That is not required because
Alright,
I have
second
stated.
part, I'm not getting into
Yes,
that. You
yes,
just file it. Let the said affidavit be filed within a period of 10 days from today with
Can it
copy
be
to the other side.
2 weeks. Can
2
it be?
weeks. Matter released from part third, list after 2 weeks on a date to be fixed by the petitioner. By the registry. Release corridor.
Lordship had hardly meter length. Lordship, in fact, had hardly meter in length. So it would have been
Yes, but now we don't know. Mr. Saikia, nowadays there is some notification. Part third matters, I think, generally should not be kept for more than 3 months. It gets released. So,
obliged.
This is item number.
My lord, the prayer was made in the morning. A prayer was made on.
You want some accommodation?
Yes.
You're unwell?
I am the petitioner. I want to file an additional affidavit.
All right. As prayed for by Mr. A.K. Purkastol, learned counsel for the petitioner, list this, which is not opposed by the other side, list this matter on such and such date to enable the petitioner to file rejoinder to the affidavit in opposition filed by
the private respondent.
10 to
50.
By respondent number
10 to 15.
10 to 15.
My lord.
I let it come up in any date after
lists
15th of August.
Did your date on such and such date question?
Obliged.
All right.
My lord. 21st. I have got another.
Give a date.
Any other date. Besides 20. Late.
Obliged.
Deeply.
Lordship, the engaged counsel is in another court. The matter will be taken after some time.
Engaged counsel is?
In another court. The matter may be taken after
Who
some
is
time.
appearing for the respondents? What is this matter? What is this matter?
Lordship, I'm not in this case, so I don't know.
Yes, who is appearing for the respondent? No one. Huh? This is the second last matter of the list. Ajay Gira Koilo. All right.
May I please in this case, the petitioner purchased an insurance policy lordship on 29/7/2016 lordship. Annexure 1, page 19. Relevant page 25.
Page?
Annexure 1, page 19. Relevant page lordship, page 25 lordship.
This is the insurance policy?
Yes, lordship.
Life insurance policy?
Yes, lordship.
Yes. And relevant 21?
25 lordship.
25?
Yes, lordship. Below lordship, he shows the option lordship, lifetime income.
Please speak little loud.
Lordship, the petitioner shows the option of lifetime income with cashback lordship. Below the table lordship.
Yes.
Lordship, now page 29.
You are referring to which one? Lifetime?
Lifetime income with cashback.
Yes.
Lordship, then lordship, page 29 lordship.
Yes.
Benefits lordship, table lordship, below. Under this option lordship, the petitioner shall get income till his death at the rate of 10,788 per month lordship.
At the rate of?
10,788.
Where do you get that?
Lordship, it is from page 25 lordship.
10% where do you get?
Page 25 lordship.
25?
Yes, lordship.
Where is 10% mentioned here?
It is lordship, annuity amount lordship, rupees 1,29,461
yes.
per annum lordship.
Yes.
He will get per month 10,788 lordship.
But where do you get that figure?
Lordship, it is also clear from the page 84 lordship.
Page?
84.
84?
84. I am also getting the amount lordship, it is admitted lordship. Page 84 lordship.
Yes.
Observation of
yes,
the...
I have got it. And regular monthly annuity at the rate 10,788. That one?
Yes, lordship.
All right. Yes, then?
Then lordship, page 29 lordship. Table lordship.
Yes, page?
29.
Yes.
Below table lordship, serial number 2.
Yes.
Lifetime income with cashback lordship. Lifetime income with cashback.
Yes.
Under this option lordship, he will receive an amount of 10,788 per month, and on his death lordship, immediately after his death, the company will release the entire purchase amount to his nominee lordship. If the beneficiary dies today, tomorrow the nominee will get the entire purchase amount lordship, 19,70,500 lordship. Now lordship, since 2016 lordship, August 2016, he has been receiving the amount till today lordship. But lordship,
he was receiving from?
From the insurance company lordship.
From when? 16.
31st August 2016 lordship. And policy was opened on 29.
Till when he was getting it?
Till today lordship. Till today. But lordship, since the month of May 2023 lordship, he is suffering from heart disease lordship.
He is suffering from?
Heart disease. And he approached the doctor lordship, and doctor advised him to implant permanent pacemaker lordship. And for this purpose lordship, a huge amount is required, and he is aged about 68 years lordship. He has no sufficient money for this purpose lordship. And accordingly, he approached before the insurance company to surrender the policy, Lordship, but the insurance company refused to.
Why are you refusing to surrender the policy?
Actually, Lordship, there is no.
Do you have if the beneficiary wants to surrender, he can, right?
Yes.
Is there any bar?
But Lordship, kindly peruse the order copy of the insurance ombudsman. That is our affidavit.
In this writ petition, the ombudsman order is under
yes,
challenge.
Yes. They came before this honorable court before. Yes, that is 179. Page 179.
Order dated 28 to 24.
Yes. Lordship, may kindly peruse the operative part. Observation and
1 second.
conclusion.
Page
179.
Page 179.
Yes.
It's not annexed in the writ petition.
No.
Huh?
Yes,
This is our affidavit.
In my writ petition, page 31, Lordship.
Page 30?
1, Lordship.
Yes.
Clause 6, Lordship.
No, the ombudsman order?
Ombudsman order was not there.
But Lordship, there is a clause, Lordship.
Where is the ombudsman order?
Yes, Lordship. Annexer 5, page 84, Lordship. Page 84, Lordship. It starts from page 82, Lordship. 11%, page 84.
82.
Yes, Lordship.
Yes.
Observations and conclusion.
Yes, Lordship. Yes, at page 84.
All right. Yes.
Yes, may I read? The complainant has proposed lifetime income plan policy of
Where are you reading from?
Observation and conclusion.
Yes, please.
Yes. The complainant has procured lifetime income plan policy of the respondent insurer with annuity option as lifetime income with cashback upon purchase price of rupees 19,70,500. The policy commenced on 29/7/16 and thereafter the complainant has received monthly annuity of rupees 10,788 with effect from 31/8/2060 till date. The total amount thus received amounted to rupees 9,71,000 and the complainant has regularly submitted existence certificate. The complainant has now applied for cancellation of the policy and appealed for refund of his policy value. He stated such amount is required for medical emergency and requested to consider his application. The respondent insurer referred to the condition 6 of the policy relating to surrender, which states the policy can in no circumstances be surrendered and it does not acquire any surrender value at any stage. Moreover, the policy had been in force since past nearly 8 years and annuity benefit were been paid while no objections were raised by the complainant. As per the policy condition, the complainant shall receive lifelong annuity and his nominee shall get purchase price on death of the complainant policy holder. Hence, the application of the complainant could not be entertained. Now, there is Lordship may come in our
according
affidavit.
to the stand of the insurance policy.
Yes, actually there is no such law.
There is no clause for surrender.
Yes,
number one.
Yes.
Second, they were already getting the
received already 9 lakhs some amount. So at that stage, how much amount they are entitled to get? This is the first thing to look after.
According to the policy, once it finishes its term, on that expiry they will get the rest of the amount.
And every month they are
so there
getting
is
amount.
no condition. There is no provision for surrender. Is it so?
Yes.
There is a condition or there is no
Yes,
condition?
Yes, Lordship. Page 31, Lordship. Clause 6, Lordship.
The policy can in no circumstances be surrendered and it does not acquire any surrender value at any stage.
Yes. 31.
Clause 6, Lordship.
The policy can in no circumstances be surrendered and does not acquire any surrender. So it is there.
Yes.
So how can you surrender then?
Yes.
Lordship, under special circumstances, I am surrendering.
That can be, but you see, how can this writ court read something into the insurance policy? This is a policy matter. You have accepted the policy.
Yes,
you knew the
FILUC policy was.
You knew what is the terms and conditions of the policy.
Yes.
Isn't it?
Yes,
no one forced you to take this policy. You could have taken it from someone else. And this policy is under Kotak.
Kotak Life Insurance. A FILUC policy was there.
How are rates maintainable in this?
Yes, rate is not maintainable, Lordship. I have also stated in my para 4 that is as per 17.8 of the Insurance Ombudsman rules. This is only binding upon the insurer, and REIT court has no jurisdiction. They come before this honorable court for seeking the.
Where have you said all this?
Extraordinary.
Where have you said it?
Yes, in my para 4 of my affidavit. That is page 106 from the continuation from the writ petition.
What is the alternative remedy available?
Alternative remedy is the consumer court, because in the general insurance case, all will go to the insurance consumer court.
Insurance Ombudsman Act by rules khon ase niki?
Lordship, I have annexed the rule, Lordship. I have annexed the rule, Lordship. Annexed 6. Annexed 6 starts from page 87.
Rule is there.
Page
87.
It is rule 17.8.
17.8.
17.8. The award of insurance ombudsman shall be binding on the insurers or insurance broker as the case may be. 17.8.
Yes, 94.
Therefore, the petitioner has to accept the order of the ombudsman.
Mr. Counsel.
Lordship, I am relying on two judgment, Lordship, on the Supreme Court, Lordship.
You see, what I don't know what judgment you will show, but the policy is very clear.
Yes, Lordship.
And how will a writ court under Article 226 of the Constitution read something to the policy or amend the condition of the policy? The policy says this, it cannot be surrendered.
Yes, Lordship. Immediately.
Then what is wrong in the ombudsman order?
There is no wrong.
Then how can this court exercise its discretion?
Lordship, on equity, Lordship, your Lordship direction may save the life of the petitioner, Lordship.
That comes later, but you see, for this court to exercise equity, there has to be some injustice done. Now, this is purely a contractual matter. You cannot stretch our hands so far that ultimately it will open a Pandora's box. All sort of cases will come and say equity demands because the person is old, and this court will end up in amending the conditions of contracts and policies. That cannot be. Anyway, give me those judgments.
But in this case, Lordship,
give me the judgment.
Yes, Lordship, I am relying on first 2011 5 HCC 697, Lordship.
Paragraph
33, Lordship.
30?
33.
Yes. This is an alternative remedy.
Yes, Lordship.
Yes.
May I read, Lordship?
Yes, you may read.
Apart from the above, even on the question of maintainability of the writ petition on the account of arbitration clause included in the agreement between the parties, it is now well settled. It is well established that an alternative remedy is not an absolute bar to the invocation of the writ jurisdiction of the High Court or Supreme Court, and that without exhausting such alternative remedy, a writ petition would not maintainable. The various decisions cited by Mr. So-and-so would clearly indicate that the constitutional powers vested in the High Court or Supreme Court cannot be fettered by any alternative remedy available to the authorities. Injustice, whenever and wherever it takes place, has to be struck down as an anathema to the rule of law and the provision of
this
the
is
Constitution.
Dwarkanath's case way back. The apex court have said injustice, if it is there, the arms of the court under Article 226 is long enough to reach. But here, where is the injustice?
Lordship, I'm coming, Lordship. As per terms condition of the policy, Lordship, the petitioner had chosen the option of lifetime income with cashback, Lordship. And as per that terms, Lordship, petitioner shall receive monthly annuity till his death, Lordship. And on the very next moment of the death, the company will refund the entire purchase amount, Lordship. Then, if the company releases the amount today, Lordship, the company will not suffer any loss, Lordship.
Alright, next decision.
Next, Lordship, 2000. 2001, Lordship, 2001 to HCC 160, Lordship. Paragraph 10 and 11, Lordship.
Yes.
Lordship. Article 226 of Constitution confers extraordinary jurisdiction on the High Court to issue prerogative writs for enforcement of the fundamental rights or for any other purpose. It is wide and expansive. The Constitution does not place any fetter on the exercise of extraordinary jurisdiction. It is left to the direct discretion of the High Court. Therefore, it cannot be laid down as a general proposition of law that in no case the High Court can entertain a writ petition under Article 226 of the Constitution to enforce a claim under a life insurance policy. It is neither possible nor proper to enumerate exhaustively the circumstances in which such a claim can or cannot be enforced by filing a writ petition. The determination of the question depends on the consideration of several factors, like whether a writ petition is merely attempting to enforce his/her contextual rights, or the case arises important question of law and constitutional issues, the nature of the dispute raised, the nature of the inquiry necessary for determination of the dispute, etc. Lordship. Then, Lordship, is para 11, Lordship. The position that emerges from the discussion in the decided cases is that ordinarily the High Court should not entertain a writ petition filed under Article 226 of the Constitution for mere enforcement of a claim under a contract of insurance. Where an insurer has liquidated the claim, in case such a writ petition is filed, the High Court has to consider the facts and circumstances of the case, the nature of the dispute raised, and nature of and other relevant factors before taking a decision whether it should entertain the writ petition or reject it as not maintainable. It has also to be kept in mind that in case an insured or nominee of the deceased insured is refused relief merely on the ground that the claim relates to contextual rights and obligation, and she is driven to a long-drawn litigation in the civil court, it will cause serious prejudice to the claimant other benefits of the principle. Since the petitioner under special circumstances is before this honorable court, Lordship, if they are to go to the civil court, Lordship, before the decision of the...
I am not, Mr. Counsel. In fact, they have, though they have argued the point of alternative remedy, this court is making its mind very clear. This court is not dismissing this petition on the ground of availability of an alternative remedy. However, this court is of the opinion that what you are trying to ask is something beyond what is provided in the policy. In fact, there is a categorical bar for surrendering the policy, based on which the Ombudsman has passed the order. This court doesn't find any infirmity in the order of the Ombudsman. So this court is deciding the matter on merit. The decisions you are citing are on maintainability. This court is not, I'm not inclined to reject it on the ground of maintainability. I will reject it on the ground of merit.
Lordship, then page 93, Lordship.
Unless, of course, you show that you have a case where this court can amend the terms. But that cannot be. You see, how can this court start modifying the clauses of the insurance policy? Can the court do that?
But Lordship,
And no circumstances, however grave they can be, this court cannot do that. This will create a lot of difficulty. You have accepted. Tomorrow everybody will come before this court and say ki no, because of an exceptional circumstance, now under Article 226 you mold the clause or you expand the ambit of the clause. How can that be done? You see, Mr. Counsel, if that clause 6 was not there, maybe, I'm saying maybe, in that situation the court could have granted you some relief. But there is a specific bar. Is it yes or no?
Yes, Lordship.
That bar is there. Now when that specific bar is there, how do you expect the writ court to lift that bar?
But Lordship, the insurance company already suffered no loss, Lordship.
It's not a question of the insurance company suffering loss or no loss. The question is, how can a court direct lifting of a bar which is available at the policy which you have accepted? This is a matter between the insurance policy and the policy holder. You have accepted this clause. You knew all along that you cannot surrender. Yes or no? And you were accepting those annuity options all along. You have got till now some
9,70,000.
Yes, you have taken that. This court emphasizes your position. Fully emphasizes your position. But at the same time, there has to be something more before this court exercises discretion, correct? Yes, you want to show something. What is that?
Page 93, Lordship.
93.
Yes, Lordship. Clause 15 of the insurance ombudsman to act insurance ombudsman rule, Lordship.
93, yes.
Clause 15, Lordship.
15.
Yes, Lordship. Subclause 3, Lordship. The ombudsman may obtain the opinion of professional experts if the disposal of the case warrant it, Lordship. The ombudsman.
This is the discretion of the ombudsman.
Yes,
what professional expert's opinion would be required?
Yes,
Clause 6 is absolutely clear, Mr. Counsel. You are trying your best. This court appreciates your arguments and your efforts. But I'm sorry, though you have appealed to the heart of this court, my mind says otherwise. All right?
If your Lordship directs to release the rest 50% amount, Lordship, then if your Lordship directs to release the 50% amount, Lordship, then also Lordship he will get some remedy, Lordship. Otherwise, Lordship, if tomorrow something happens, Lordship, because it is his money, Lordship, not insurance money, Lordship, and there is not any waiting period, Lordship.
This money is what money? The interest.
The purchase amount is the amount of the petitioner, Lordship, and there is no waiting period, Lordship. For there is no waiting period, Lordship. Till on the moment, Lordship, he dies, Lordship, very next day his nominee will get the entire purchase amount, Lordship. So, Lordship, under special circumstances, Lordship.
In case they make a representation,
Yes, Lordship. They may make a
you may consider
Yes, consider.
that much liberty I can give.
Yes.
Yes, Lordship.
Yes, they may file a representation.
Yes, this is item number 12. এইটো অলপ ডাঙৰ হ'ব, তুমি ল'বা নে বেলেগক দিম? সেইটো হ'লনে নাই?
Yes, Lord. Yes, Lord.
Dash, yes. 2. Yes, yes. No, binding on them. No, binding upon the insurers only. Insurers.
Case 25 Lordship. Yes, Lordship. Purchase price. Purchase price 1,90,000. Lordship. 20 lakhs. Lordship, 19,70,500. Some time may be granted. Lordship, 15 days, Lordship. 15 days, Lordship.
All right.
May I please, Lordship? My Lord, in this case, as per direction of this Honorable Court, my Lord, we have both the parties submitted the written synopsis and arguments, my Lord. And the case is, in brief is that, my Lord, my Lord. My Lord, case in brief is that the petitioner has applied for a permission, my Lord, to collect the barks of Badgela tree, my Lord, on 1/2/2010, and pursuant to that a verification was made, and after verification, my Lord, their version is that there is a Supreme Court order. But my submission is that, my Lord, there is no ban made by the Supreme Court, my Lord, regarding barks collected from the revenue villages. There is no bark. There is no bar, my Lord. Supreme Court, they have taken the plea, my Lord. This is absolutely misleading. They wanted to mislead this Honorable Court by citing the Supreme Court judgment.
Their judgment.
And this is their main case, my Lord. That the Supreme Court has given a bar to transport the barks, trees, etc., my Lord, from outside the Assam.
Lordship already provided by Mr. D. Gogol, Lordship. 2000. Yes, Lordship, 2002-10 SCC 634. Yes.
You were allowing them. You were allowing the allowing them to distribute it within the state, but not outside the state. I think that was the concept.
No, my Lord. Earlier, my Lord, they allowed me to transport those collected barks outside the Assam.
Correct. And now they are saying
subsequently they stopped.
They stopped. They stopped in toto.
My Lord, in total.
And Lordship.
And all the collected barks have been taken into departmental custody.
Right.
That also they destroyed by Lordship.
That has been destroyed.
They decomposed, Lordship, because long time.
No, but time. You are only relying on this decision of Supreme Court.
Supreme Court.
And this decision came on. 14 February 2000. When is the order, impugned order is dated?
My lord, impugned order dated is page 95.
Date?
Date, my lord. 2002, page 95. Page 95, my lord.
Page 95.
95. Annexer S.
Please say, the date, please.
The departmental custody.
Date.
Date is 26/4/2012.
12.
My lord.
Yes. And what is the order? What does it say? Can you read the order?
My lord, with reference to the subject cited above, you are requested. This is letter written by the Chief Conservator of Forest to the Divisional Forest Officer, my lord.
Yes.
With reference to the subject cited above, you are requested to furnish the following information as per format for taking necessary action. Please submit the report in respect of phase 1 and phase 2 of collection of Badgila barks separately as reported by you by the letter dated so-and-so, dated 17/2011, dated 19/4/2012. You are also requested to take the collected Badgila barks under departmental custody until further
when
order.
is that order by which you are allowed?
My lord. That is, my lord.
Is that before 2000 or after 2000?
Before that. My lord, date is order to order. Annexer, my lord, Annexer J, Annexer J, Annexer J, page 1, Annexer J, 39.
This is Bora.
Page 39,
see,
page
on 9, they had
Annexer
submitted their application on 1/2/2010, right? Then DFO asked report from range office. Then DFO submitted application to the council on 19/2/10. 25/10, the head of department wrote to DFO to allow the petitioner to collect the barks from revenue villages. 28/7/10, DFO passed the order and allowed the petitioner to collect barks. This is done after the order of the Supreme Court. You have done it.
Yes, Lordship.
Then allow
He was not
petitioner
aware
for
about-
transportation of barks outside the state. This was done in 2011.
2011,
At that time already the Supreme Court order was there.
Perhaps he do not know the...
No, but and then
Thereafter PCC have State of Assam has
petitioner
communicated.
deposited royalty.
Some wrong has been done, I also admit, Lordship. After Supreme Court's order.
But what has happened, because you see that is an interim order, but what has happened ultimately to that case?
Lordship, my additional affidavit, Lordship.
What is the status of that case?
Latest status, we do not know, Lordship, but notice was issued, Lordship. He has for FTR, Lordship.
Huh?
Notice was issued to him.
For what?
Lordship, for regarding, Lordship, how much articles are seized, and authority has found that there is they have not collected from revenue villages, Lordship.
Sorry, I am not following you. Notices have been issued for?
They have collected huge amount of Badgila barks, Lordship. And Lordship, authority has examined the revenue villages from where they have collected, and authority found that there is no such trees from that villages which are nearby reserve forest eleka, Lordship. So they suspected that Badgila barks were collected from the reserve forest, Lordship. That is why they have issued notice, Lordship.
When was this notice issued? After their barks have been taken into custody?
Notice issued on paragraph 3 of our affidavit 206, running page 206, Lordship. The additional affidavit filed on
Actually, there has been a lot of time left after this court had heard you both.
That notice was also, my lord, issued, can we see, my lord? Subsequent collection, not the Badgila bars taken into custody. That barks has not issued any notice.
Counsel, you see, this court is asking a very simple question. What is the status of this case, T.N. Godavaran? What has happened? Because this is an order, this is an interim order, and this was passed way back in 2000. On 14 February 2000. We are now in 24.
My lord, in the record, my lord, pursuant to this honorable court's order, they have earlier submitted the order of the Supreme Court. It is in the record, my lord. There is 1997 2 SCC 267.
Yes.
My lord, pursuant to order, this honorable court's order, they have submitted this.
What happened here?
My lord, this is a different case, my lord, in the difference footing. My lord, bar was made for felling of trees and, my lord, transporting of trees.
Here it says there shall be a complete ban on the movement of cut trees and timber from any of the 7 northeastern states to any other states.
Yes, my lord. That is with regard to the timber and felling of trees, but not the barks collected from the revenue village. My lord, kindly see paragraph 4.
I am reading.
My lord.
Read.
There shall be a complete ban on the movement of cut trees and timber from any of the 7 northeastern states to any other state of the country, either by rail, road or waterways. The Indian Railways and the state government are directed to take all measures necessary to ensure strict compliance of this direction. This ban will not apply to the movement of certified timber required for defense or other government purpose. This ban will also not affect felling in any private plantation comprising of trees plantation in any area which is not a forest.
Just read your synopsis.
My lord. But from the beginning, I will.
Yes.
Pursuant to the application dated 1/2010 of the petitioner for collection of barks of Badgila tree and Ayurvedic medicinal herb from the revenue villages under Kuklung and Amteka forest range under the BTC area, the Divisional Forest Officer DFO Chirang called for a detailed report from the range officers regarding availability of Badgila trees in revenue villages, and on the basis of the detailed reports submitted by the range officers, the petitioner's application was placed before the council head of the Department of Forest BTC for consideration. The CHD, for consideration of all the reports, directed the DFO to allow the petitioner to collect the Badgila barks from the revenue villages by the letter dated 25/2010. Thereafter, the DFO directed the range officer to allow the petitioner to collect the barks of Badgila trees by maintaining the procedure so that lifting order for transporting of barks could be issued. After collection of Badgila barks, the petitioner applied to DFO for lifting order for transporting the Badgila barks outside the state of Assam, and the DFO placed the same before the Chief Conservator of Forest, CCF, BTC O, by the letter dated 24/2011, Annexer I, page 38, directed the DFO to allow the petitioner for transporting the Badgila barks of 33,821 kg outside the state of Assam by rail/road on payment of necessary fees, etc. Accordingly, the petitioner was allowed to transport the said barks on payment of royalty of rupees 3,383 and VAT rupees 457 by letter dated 28/2011. Annexer J.
Badgila barks means the dry leaf.
Matlab, the skin of the trees.
Skin of the trees.
Skin of the trees.
And that ban is
with respect.
paragraph 4
my lord.
on the
Trees,
movement of
cut
cut trees.
Cut of trees and timber.
This is skin of the.
This
tree.
is not skin. We are dealing with the skin of the.
That's
tree.
what. That's what.
My lord.
Bark means the skin of the tree.
Skin, yes.
And the ban is of cut trees and timber.
Timber.
So according to you, barks are not covered by this judgment. This is your case.
Yes, madam.
Correct?
Yes, madam. Yes.
Where do we get the definition of bark?
My lord, bark, it is in the bark skin. It is generally.
Where is it? Have you any literature on
in
that?
Assamese manual, bakoli of the.
No, but are you carrying anything?
Madam.
Because in order to suppose this court has to distinguish barks from this, then perhaps I'll have to refer to some meaning.
My lord, this is a tree, my lord. Ayurvedic medical tree, my lord. The bark grows, if cuts also, it is automatically grow again. So, entire tree is not,
in
my
other
lord.
words, you want to leave it to me for doing a homework.
My lord.
Definition to analyze this question.
As per Google Lordship,
Yes.
bark is outermost layer of stuff.
That's what. This is
Outermost.
as per dictionary.
Wikipedia Lordship.
Wikipedia, this code will not. Rupak, library pra এখন ভাল dictionary এখন আনাই লোৱা. All right, go ahead.
My lord.
So that is the short point to decide.
Short point, my lord.
According to you, it is covered by the Supreme Court decision. Right. That is the only ground, because subsequent about calling them for any hearing and all, that's a different issue. As far as this writ petition is concerned, their cases, your order of restricting it to Bongaigaon and subsequently directing to take subsequently the action of taking the barks into custody is what under challenge.
Yes.
Correct?
Yes. And their contention is that, my lord, in their synopsis they have written that the barks taken into departmental custody, their version is that those were seized. Actually, if it is seized, it is under section 49 of the Forest Act, it is to be seized. The general procedure is there.
See, I don't want to get into that part right now, because that is not what is.
That is not the
issue
here.
Correct.
Yes, madam.
The issue is not about that. The issue is that you were initially granted permission. Accordingly, you started.
Yes.
Thereafter, they restricted it to Bongaigaon.
And thereafter,
then they took it to custody. That is what is under challenge.
That is my
Now, the defense version is that there is a Supreme Court has given a ban, and in term of that ban, they have taken the barks into custody.
My lord.
Correct, Ms. Bora?
Yes, my lord. Yes, and that is also, my lord, kindly see my...
Another lordship thing is, lordship, he has collected...
I cannot hear you properly.
He has allowed to collect earlier from the revenue village, and however the amount he has collected is much more huge than authority has verified. The revenue
Those are
village
not available in the impugned order. There you have not said all that. Have you said it?
In order not said,
Then
but in affidavit we have stated.
You cannot improvise your stand. The order has to speak for itself.
Yes.
Orders are not like wine which will become better with age.
My lord, in the Miss case, page 16, my lord, the SDO, I have given an application before the SDO after passing an interim order by this honorable court long back, my lord, and on that application, they have rejected this application on the plea, by specific plea, my lord. The prayer of the petitioner prayer cannot be allowed, since there is a ban order of Honorable Supreme Court. It is written, by the way, page 16. On that ground, it was rejected. in my miss case. Miss case, that is, my lord, 833/2015.
Dictionary for Anila Niki. Suppose this court comes to the finding that the action of taking these barks from under custody is wrong. Is illegal, then consequently this has to be returned, but then they have already become bad.
Right. So, my lord, next questions come, my lord, compensation. I have prayed in
yes,
my
I can
prayer.
see.
Compensation I have prayed, adequate compensation.
Then you will have to conduct an inquiry, assess the damage, and
It is now difficult, Lordship, because already decomposed.
no, if a wrong is done, the wrong has to be made good. You cannot perpetuate the wrong. The first question is that whether taking the barks of the petitioner into custody is right or wrong, correct or wrong. That is the issue. Now, your stand is as per Supreme Court order. The Supreme Court order talks about that cut trees and timber. Here, what is taken into custody are barks.
Bark.
Well, I didn't know. Meaning to. Bark. Oh. Which is that the two impugn orders are at page
95, my lord. '94 also, my lord, up to Bongaigaon. He has created the problem, my lord, first. The divisional forest officer, destination up to Bongaigaon, and thereafter, my lord, chief conservator forest has taken the entire bark into custody.
An affidavit in opposition was filed.
Yes, my lord.
Filed by DFO, two affidavits, Lordship.
2
Two affidavits filed by DFO. One is filed by Sri Subhasis Das. Second one is filed by Sri Brahmananda Patil.
Just additional.
Lordship, both the Supreme Court judgments are in same writ petition, but in one is in IA.
But it talks about cut trees.
Cut trees in main case, and in IA it is stated that dying winefall trees, driftwood, grasses, etc. also.
Huh?
In IA,
it says what?
In IA it is stated restrain the respondent number 2 to 32 from ordering the removal of dead, diseased, dying or winefallen trees, driftwood and grasses, etc. also.
But that is also not barks.
But barks also meaning by the same ultimately.
How barks would be included?
Dead disease, dying winefallen trees also.
How does come barks?
Driftwood, grasses also.
Because you mean to say because the skin is part of the tree.
Yes.
So if tree cannot be transported outside the state,
even dead trees,
then the skin of the tree will not be able to. Is that what you're trying to say?
Yes, Lord.
Because it's part and parcel of the tree.
Yes, Lord.
Right.
In IA 421 in WPC 202 of 1990.
Where is that order?
I have stated 1990.
There are so many orders.
2002-10 STC.
Huh?
2002-10 STC.
2002-10
STC. 634.
664.
2010 SSC.
Yes, Lordship. In same writ petition, Lordship. Writ petition is the same. This is in IA and that is in...
What? There are a lot of documents actually.
Lordship, I am supplying.
I have the 97 decision, but which
97 decision is in writ petition number 202/1995 and IA is also in 2002.
In their affidavit, this citation has been mentioned by them.
Give me a copy of that. It would a better copy as in Ms. Bora, please see if there is a better copy of this notification available with you.
2020. Same Supreme Court হয় খালি তো IA টো দিছে না মোক ইটো এটাই আছে Same Supreme Court of judgment they have to 1990 আৰু IA
So this I have. This is an IA, but this is of 2000. The order is of 2000. After this, what has happened?
2000.
Its status is not known. You find out what has happened after this. Because the impugned actions that you have taken is sometime in 2014. And in 2011 you had given them permission. Whether these orders were still subsisting or not?
No, my lord, that is not applied in our case.
No, that is not known. Ms. Bora will have to find out what has happened to these cases. Ms. Bora, you following what I am saying? Because
Lordship.
this order
is in 2002, Lordship.
2000.
2000, Lordship.
It is of 2000, 14 February 2000. And you see, in this IA at that time, notice was issued.
Notice was.
So after that, what has happened?
Well, this is also, we restrain respondents number
And this 97 order is
Order
also an interlocutory order. It is not disposal. You see, the case was listed on 25/2/97 as part heard for further hearing. So what has happened subsequently? Has these
final order of
yes, whether it has been
1995.
concluded?
Thereafter, no orders.
So I think it is important for us to know this.
Final order I shall
Yes,
provide.
Dr. Lekha. During the course of the hearing and while the written synopsis submitted by the parties were considered, it has come to light that the status of the case of T.N. Godavarman Tirumul Pad versus Union of India pending before the Supreme Court in WPC number 202 of 1995 and the interlocutory application IA number 421 is not available on record. Stop. This court is of the considered view since the defense since the state respondents have taken the defense that the barks of the petitioner were taken into custody and was restricted for transportation outside the state of Assam in terms of the aforesaid orders, in terms of the orders passed by the Honorable Apex Court in the aforesaid writ petition and interlocutory application, the status of the aforesaid petition and applications is essential and necessary for further adjudicating before going into further adjudication of the matter. Stop. List the matter after 2 weeks.
My lord.
List the matter on such and such date.
My lord, and the last order, my lord, reflected in, my lord, 23/4/2024, my lord. May I draw your attention, my lord?
Yes.
23/4/2024 order.
It is reflected.
Yes.
The outcome.
No, outcome.
23?
My lord, they are always insist on the adjournment this way or that way. And the last order is given, my lord, strict order has been given,
But
my lord.
Mr. Counsel, this
My
time
lord,
it is not...
My lord, I am trying to finish my case,
Correct,
my lord,
but
since
Mr.
2013,
Counsel,
my lord.
this
In
court-
this way, my lord, this matter is lingering, my
Please
lord.
understand
This is the
that
ultimate, my lord. This
it
is
is
the
not
ultimate.
at the instance of them the matter is getting adjourned. But this court has heard you. The matter was kept as part heard.
So,
but
my lord, 1 day, 2 day time may be given. No further time may be given. Otherwise, my lord, I am in
have
trouble,
it
my lord,
by
because I am
next week?
facing the trouble.
Lordship.
Can you have it by next week? Next week or later than it on such and such date.
And this, my lord, this order is also related to the trees only.
Mr. Counsel,
Well,
bark is a part of the tree.
My lord, bark is yes. my
Then,
lord. But
how can you say it is not?
To remove the barks, my lord, tree is not felling.
Yes.
Tree is not
That
felling.
is a matter which needs to be adjudicated, Mr. Counsel.
My lord.